Thank you very much, Madam Vice President. Excellencies, distinguished delegates. As you've just noted, the Human Rights Council Resolution 53-6 requested that the UN Secretary General conduct an analytical study on the impact of loss and damage from the adverse effects of climate change on the full enjoyment of human rights, exploring equity-based approaches and solutions to addressing the same. The Earth has never, since records began, seen temperatures as high as those experienced this summer between June and August. 13 of the past 14 months measured at more than 1.5 degrees Celsius warmer than the pre-industrial era, an indication of how perilously close we are to being unable to stay below the most ambitious Paris Agreement target. We are entering increasingly uncharted and dangerous times on a planetary scale, with risk and harm to people accumulating alongside unrelenting greenhouse gas emissions. We are witnessing climate chaos multiplying from increasing intensity and frequency of extreme weather events to rising sea levels, relentless forest fires, coral bleaching, thawing of permafrost, and melting of glaciers. We know that losses and damages from climate change escalate with every increment of global warming, according to the Intergovernmental Panel on Climate Change, while limiting global warming to 1.5 degrees Celsius would substantially reduce them. Mitigation and non-repetition of harm are vital as is adaptation to avert and minimize loss and damage. Yet, as the IPCC has found, climate change has already, quote, caused widespread adverse impacts and related losses and damages to nature and people, end quote. Loss and damage is already here to stay, and it is affecting the enjoyment of human rights both directly and indirectly, with cascading implications for different interconnected human rights. For example, roughly 37% of heat-related deaths can be linked to climate change. Premature death due to climate impacts violates the right to life, and it is a tragic and irremediable form of loss and damage. An estimate for the scale of loss and damage that is more easily quantified in developing countries alone amounted to at least $435 billion in losses in 2020. Even these vast sums are inadequate to capture the true scope of loss and damage. Non-economic loss and damage describes harm not commonly subject to market transactions, which often takes the form of human rights violations. Since climate change exacerbates many harms, including biodiversity loss, ecosystem degradation, soil depletion, and desertification, it frequently impedes the effective enjoyment of the right to a clean, healthy, and sustainable environment, as well as many other interrelated rights. For example, disrupted education through climate change can have serious implications for children's rights and futures. We also know that loss and damage disproportionately affects those in vulnerable situations, and the extent of harms is often both underestimated due to a lack of disaggregated data and unaddressed due to inadequate or discriminatory laws. There is a legal, moral, development, and economic imperative to provide remedies for climate change-related harms. International human rights law in particular requires states to avert, minimize, and address loss and damage associated with climate change and its impacts on human rights. All countries should seek to remedy, including through providing financing, the climate harms to which they contributed, consistent with their international human rights and other obligations. In accordance with human rights law, and as reiterated by the Secretary General in this report, states must ensure that people whose rights have been violated because of loss and damage from climate change have access to justice and effective remedy. This can encompass reparation, compensation, restitution, rehabilitation, satisfaction, and guarantees of non-repetition. Remedies for loss and damage should also be informed by the principles of equity, the polluter pays principle, and common but differentiated responsibilities and respective capabilities. Historical emissions source attribution is critical to the overall attribution of responsibility for climate impacts. From 1850 to 2002, industrialized countries produced 3 times the carbon dioxide produced by the entire global South. The obligations of states in the context of climate change extend to harm that occurs to rights holders both inside and beyond their boundaries, including as a result of their failure to adequately regulate the emissions of businesses under their jurisdiction. In this regard, the report notes that according to the Carbon Majors database, over 70% of global fossil fuel and cement carbon dioxide emissions since the Industrial Revolution can be traced to 78 coal, oil, gas, and cement producers. There is thus a rationale and legal basis for exploring the accountability of both states and such businesses accountable for climate harm and reparations. Existing loss and damage mechanisms under the UN FCCC are not currently designed or intended in and of themselves to fulfill the human rights obligations of states to provide effective remedies for climate harms. Furthermore, the initial pledges for the Loss and Damage Fund amounting to $661 million covers only a fraction of the estimated bill for 1 year of loss and damage. Given the scope and scale, as well as the multiple forms in which loss and damage due to climate change manifests itself, a broad set of human rights and equity-based approaches is required to comprehensively address loss and damage. As the IPCC has confirmed, such human rights and equity-based approaches lead to more effective and sustainable outcomes. The Secretary General's report on human rights and loss and damage identifies, in that regard, 5 key approaches. First, the report calls for integration of human rights in laws, policies, and assessments concerning climate change and related loss and damage. This includes effective measures to ensure loss and damage responses are informed by the participation of affected persons, taking into account intersectionality and historical and structural discrimination. Such responses should integrate gender-responsive, rights-based approaches to make funds directly accessible to those on the front lines of the climate crisis, including environmental human rights defenders, and they should support rights-based mobility pathways. Second, the report urges building climate resilience through social security and a just transition towards a human rights economy. The Secretary General calls on states to establish and strengthen universal rights-based social protection systems to increase people's resilience to the adverse effects of climate change, noting that developed countries should seek to support the investments of developing countries in strengthening social protection systems. Third, it advances human rights and equity-based approaches to mobilizing financing and freeing fiscal space for the benefit of people suffering from loss and damage. This could involve, for instance, a fair and just phase-out and repurposing of fossil fuel subsidies, the introduction of taxes and levies, including windfall taxes and solidarity levies, such as on shipping, aviation, and fossil fuel extraction, and the establishment of an effective price on carbon. Such efforts should be complemented by debt relief and debt restructuring for developing countries, especially those most in need and most affected by climate change. Fourth, the report calls for an advancing access to judicial remedy and accountability for loss and damage. States should seek to advance legal, policy, and normative measures to hold polluters accountable, including for disinformation, and support loss and damage-related claims, including, where applicable, extraterritorial climate litigation. They should also seek to ban advertising by fossil fuel companies. We welcome the recent proposal by Vanuatu, Fiji, and Samoa that the International Criminal Court should recognize ecocide as a crime. This follows on the heels of a request to the International Court of Justice to issue an advisory opinion on the legal obligations of states in relation to the adverse effects of climate change. The proliferation of climate litigation around the world further highlights the ways that judicial systems can advance accountability for climate harms, even when governments are failing to sufficiently protect people. For example, in the first ruling of its kind in Asia, South Korea's Constitutional Court recently found that provisions of the country's Climate Act, quote, failed to fulfill the state's duty to protect fundamental rights, quote, including by infringing on the right to live in a healthy environment and by shifting an excessive burden to the future. Fifth, the report discusses how an approach to loss and damage informed by transitional justice could be used to ensure the non-recurrence of harm, document the causes, including the responsible actors, and the consequences, including the human rights impacts of climate change. It could allow for the elaboration of climate reparations on a systemic and historic scale and redress holistically the non-economic dimensions of loss and damage that other approaches may inadequately address. While existing mechanisms prove inadequate to match the scale of the crisis, consideration should be given to new mechanisms. In his analytical study, the Secretary General hence encourages states to consider establishing a group of experts or other mechanism on climate justice to explore human rights and equity-based approaches to climate harm, including loss and damage and associated human rights dimensions. Addressing loss and damage equitably in a manner consistent with state human rights obligations requires wide-ranging remedies that take on the root causes of climate change, including its structural, temporal, collective, and transboundary dimensions, and hold those responsible accountable. I look forward to your discussion today and on Monday of the Secretary General's analytical study of human rights and loss and damage. I urge you all to consider its key findings and use this interactive dialogue as an opportunity to share ideas and as a stepping stone towards further action to operationalize its recommendations. Thank you for your attention.